Al Henshaw here again for the Constitutional Crisis channel. And I've got a beaut for you today. It's going to be somewhat of a longer video, and it may end up being in two parts. Case is Flemming v. Nestor, 363 U.S. 603. This is the case where the Supreme Court held that there was no right secured by the Constitution to the receipt of social insecurity benefits. Now, I've been long aware of this case. This goes back for me over 20 years, but beside the point, because I've recently reviewed it. And when you look at things through the prism of state versus territory, which I'm doing now, and hopefully I'll be teaching you how to do, you don't need to be an expert at it, but when you do that, things jump right out. And this case, 5-4, another one of those infamous 5-4 cases, but it wasn't decided when the four horsemen were on the court, is another example of what the trouble is with the system. And I'm going to give you some more background that shows it even more clearly. By the way, a quick side note here for me, a little personal thing for me, given the day of the year. It is November the 22nd, 2015, and I'm already known to be a conspiracy theorist par excellence, and you would be well advised to be one too, given the fact that the black letter law establishes all I say. I'm going to give myself a little bit more leeway in that area with this case I'm explaining to you, and I'll tell you why. Now, Flemming, first part of it is when he gets to the district court, because what happened here basically, this poor bastard had come over here in 1913 when he was a kid, and this was 1956-57, and he had worked at the time for 16, 17 years under the social insecurity system, and the government was stealing his money in the form of taxes, so they could pay him quote-unquote benefits later. Well, what happened is the federal government comes along in 1955, passes a law that makes it a crime to be a member of the Communist Party. Now, I don't know if I would agree with that. If anything, if you're going to be stupid and join an outfit like that, fine. Whether that's a crime, I don't know. But the problem they had here was this occurred with Nestor in the 1930s. And they passed a law in 1955. That's known in constitutional parlance as ex post facto. You can't pass a law that makes something criminal, way after it happened. You can't do that. And that's what they did here. And they deported him back to Bulgaria, I believe. And when they did that, the government terminated his social insecurity benefits. Well, he took issue with that and somehow got a hold of a reasonably good attorney or attorneys, I don't know which. And they went to fight that, and when they did so, they won in the federal district court. And the court said, yeah, you're right, that's not only ex post facto, it may well be a bill of attainder, the taking of property without judicial process. There wasn't even an administrative hearing here, crying out loud. So he wins. The Secretary of HEW, that's where the Flemming comes into play. That was his name at the time. They appealed to the Supreme Court. I think this must have been a 3-judge court because it went straight to the Supreme Court. There was no Court of Appeals opinion, of which I'm aware. It gets there by 5-4. These bastards hold that there's no problem with any of this. There's no ex post facto law here. There's no bill of attainder. There's nothing. And they therefore reversed, and they in effect put this man out on the street without any benefits. Now, as bad as that is, you go to the Dissenters again, and 5-4, and I'm going to call out the 5 that were in the majority here. They should have known better. And they were Tom Clark, who was virtually on the verge of retirement then, Charles J. Whitaker, one of the worst justices in the history of the court. I may get back to that later because I want to find out a lot more about him as to why he had the problems he did on the 5 years he was on the court. But he was there. Potter Stewart, never one of my favorite justices, but he had some good days and bad days. So he was there. John Marshall Harlan, who wrote the opinion and should have known better. That is a big surprise to me that this justice had. He changed his vote, which he should have done. And he, by the way, was the court's self-recognized expert on federalism. In other words, that's cases that talk about the difference between state and federal power. And when they had cases that came along like that, they would almost always defer to what his opinion would be because he was the expert in that area. This is a case that fits right into that mold, and I don't know what the hell he was thinking about when he did this. Now, later, by the way, when he retired in 1971, because he was very ill and he knew he had to quit, and he did, but one of the last cases he wrote an opinion, I think it was a concurring opinion, And I'll get you the citation. Look for the citations underneath in the notes. You'll see this case. Oregon v. Mitchell. It's just one I don't happen to have in my head. But he wrote an opinion there that can be reasonably read, as I do, as an apology for certain of the things he did on the court, and I suspect Flemming was one of them. It may even have been an apology for his grandfather, John Harlan, who was on the court in the 1890s when the infamous case of Plessy v. Ferguson was decided. Harlan was the only dissenter at the time, 8-1, separate but equal. And it's a big deal case, and people say, oh my God, racism, neo-Nazism, this, that, and the other. No, it wasn't. And that's a case we're going to talk about at length on another video, so we're going to, at the moment, not go into it here. But I think at the end, he realized what he had done, and he must have had one hell of a guilty conscience about it, because you read this thing in Mitchell. I said, my goodness. But if he'd only had done this 12 years ago, in this case, none of this happens. So the four dissenters who have no problem with this, and you have in the four dissenters, Hugo Lafayette Black, William O. Douglas, Bill Brennan, and the Chief Justice at the time, Earl Warren, and I never had a whole lot of use for him, but he was on the right side here. You have to give him credit about that. And they were saying, without any question about it, this is a plain bill of attainder. It's as clear as can be that this should have been ruled on, and Nestor should have got the benefits to which he was entitled. But the big deal here, and I think what the court did, the majority, to elude and evade their duties once again, the primary focus was on the receipt of benefits. And they said right in its opinion that there is no constitutional right cognizable to the receipt of benefits from social insecurity. That's not the issue that should have been there. The one that was, and both sides gave lip service to it, unfortunately, but they freely admit that Nestor, had worked for 16, 17 years under the social insecurity system and had taxes taken out of his check for all that time, ostensibly to pay him the benefits he earned later. The dissenters, to their credit, at least called it what it was, compelled contributions. And see, that's the property issue, because we go on there and said, wait a minute, that was my property you took from me, and I had every reasonable expectation to get it back. That's a bill of attainder. And it puts the social insecurity system out of business. That's what we have to get in there. But they narrowly focus, and this is where the justices in the minority damn well should have known better, especially in 1959, because all of these justices were around in one or another legal capacity when this thing went into effect in 1935. They knew what it was. They knew what the American people were led to believe it was, an annuity that you had a right to. Well, that's not how the court saw it 25 years later. And they screwed this poor guy and all the rest of us until we get this case reversed, and we can do it, or at least get it distinguished from our cases so it doesn't apply. And that's how we do it. We go in there and say, wait a minute, I'm talking about my property in the form of my time and labor. That distinguishes this case from Flemming, and therefore it's not precedent in my case. Now, for me, a bigger problem with this came up from the first case of Social Security, and I think I mentioned it in earlier videos, called Carmichael versus Southern Coal Cokw, 301 U.S. 495, 1936, less than a year after the Badgers enacted this thing. And this gets there, and this is another 5-4 opinion, and it's even worse here because this one was written by Harlan Pisk Stone, worst black robe bastard ever on the court. 5-4. And what they did, and note the name of the case there, Southern Coal Cokw, who was coming in here, was a corporation, a corporate entity with no rights. And they were challenging social insecurity as to the tax on employers. Well, that was bound to be a loser, and it was. What they didn't say, well, they said it later in the opinion, and they kind of, in carefully concealed language, said that, after sustaining the tax against Southern Coal Cokw, that with regard to the tax on employees, quote unquote, the company lacks standing to challenge a tax it isn't asked to pay. They would have had one quote unquote employee, and I would have had a big issue with that definition too. They would have had one of them in this case that would have had property rights in the form of his time and labor. Social Security never gets off the ground. Bang, it's gone within a year. That didn't happen, and I blame the attorneys on the one side, and the justices, especially Stone and Owen Josephus Roberts, the switch in time that saved 9, That case should have gone 6-3 the other way, and maybe 7-2, assuming that the Chief Justice Charles Evan Hughes would have been in the majority. That's what should have happened. And if that happened, Flemming never has anything to worry about because there's never a cent taken out of all his earnings for all those years, and the government doesn't have it to steal from him. I mean, that's how big a deal this case is, and how this crap goes on in the court. They continuously ignore and evade their duties on the thinnest of pretexts. You know, that's what their Ashwander doctrine is all about, and we're going to be addressing Ashwander in its own video. That's how important this is. They use these obscure rules that you never know about. They sure as hell didn't tell me when I was in school at any point in time, and I'd be shocked if you even ever heard of Ashwander, let alone what it means. In this sense, by the way, the Ashwander case was actually a pretty big-time case on the legal merits at the time, which is a story for another day. But this is the part that includes the concurring opinion of Louis D. Brandeis and some other justices that set forth the court's kind of loose rules on status and standing in the Supreme Court. And that's what they used in Flemming to get around this. You're going to get clear and cogent examples of this later in the video on Ashwander, how they do this stuff and how it has to stop. So this case, as I said, when I read it in the context of state versus territory, this is a mindset thing, people. And I'm going to try to get you as quickly and as efficiently as I can to get into that mindset where you think about yourself as principal to agent, not guardian and ward. Once you're able to do that, a whole lot of stuff gets amazingly clearer than you would think it would. And it's pretty simple to get. I mean, not going to take you as it took me 4 decades and 10,000 hours. Hopefully get this done in a lot less time than that. And once you start thinking with that mindset, you're going to be very difficult to beat no matter what the setting is. You know, if I can do that much for you and do that much for your children, your family, and your posterities, I think I will have done my job here. Thank you.